So thank you everyone for being here. My name is Manon. I'm a French student from also Europa Master. Before that, presented something about everything that happened in Poland. They are from the same master as me. For now, I'm a student in the University of Burgundy. And at first, I was not supposed to be alone, but now I am alone, so I just hope that you're not too disappointed.
We're here with you.
I just hope that you're not losing too much. So yeah, I will present to you a few of the legal mechanisms or everything that can be used to somehow defend democracy in Europe, or at least in the European scene, because it's a little more subtle than just the EU. And we will see what works, what doesn't, why. If at any point you have something to say, a remark, a question, please go in. I will also have those little question slides because I want it to be as digestible as possible, because I know that not every one of you is a law student and not every one of you wants a lengthy expose on law. So I'll try to make it as fun as it is possible to make it. And yes, and also if at some point you have diverging opinions on what I say, also please raise your hand. I will be most happy to have you say something. So we will first have a small introduction. Then in the first part we will look at the defense of democracy using defense of democracy using standards of democracy, and then in the second part we will see how democracy is defended using specific human rights. So first of all, I have a small question for you. Do you think democracy to be sufficiently protected? You don't have, if you have an answer right now, a short one, you can say something. If you do not, just have in mind your answer or what you think, and keep it in mind as we will go further, because it will be very interesting for you to compare what you thought and what you will learn today. So at first we will see what is democracy. We will talk about a bit about democratic decay, the rule of law crisis, and then we'll touch up on two bodies that I will want to speak to you about today, the European Court of Justice and the European Court of Human Rights. What is democracy? So, a lot of definitions when it comes to democracy are based on etymology, so demos and kratos, which comes from the Greek, the people and the power. The thing is that usually those definitions are way insufficient to really carry what democracy is. Here we have also a very etymological definition provided by Black's Law Dictionary, that form of government is in which the sovereign power resides in and is exercised by the whole body of free citizens. So once again, the power and the people. But the thing is that this concept is much more wide and much more hard to grasp. And I wanted to gather a bit what will be interesting to have in mind whilst we look at the cases. So at first, we have this three-parted separation of power: judiciary, executive, and legislative. This is very traditional for definition. It's very seen by French enlightened scholars. And then there are different principles that have also been laid out by some institutions on the European scene, such as the Council of Europe, and those would be the individual autonomy and equality. The Council of Europe, which is the body that has the task of defending democracy and human rights on Europe, also really insisted on the idea of democracy by saying that democracy includes far more than just elections, and it really makes more sense to think about the will of the people idea rather than about institutional or voting structure, then we are trying to assess how democratic a country is. Democracy is better understood as something that we can always have, more or less, rather than something that either is or is not. And so this idea of defending democracy and all the little steps of democracy is really what we will see during this exposé. Another very big and important part of democracy would be accountability and transparency, because where there is transparency, there is usually more accountability, and when there is accountability, there is less risk of abuses of power. So then, you will hear about democratic decay or the rule of law crisis a little later on the presentation. So I wanted to tell you a bit more about it beforehand. So democratic decay would be a situation where all the democratic process and instances established in a country or in a state would be eroded by everything that is happening. It can be taking several shapes. It can be from a master plan, such as in Hungary, Venezuela, or Poland, where a leader, usually charismatic leader, is driving a program, so-called master plan, eroding with a lot of efforts all the democracy and democratic instances that have been planted before. It can also be reactionary, such as in South Africa and Brazil, where it is not by wish of destroying democracy, but rather by reacting to some kind of event that democracy sees itself very diminished. So it is much more complex than just a specific government rotting away democracy. And it's very usual to see the law being weaponized for this, such as in Hungary, in Poland, in Europe, for example. And it's also very important to take into account the very broad socio-economical and cultural factors that are non-negligible. A very good example of this democratic decay in Europe, and perhaps the textbook definition of democratic decay in Europe would be Hungary, where you can see a complete loss of trust in the values of democracy, backsliding, and a lot of attempts to concentrate powers into one hand. Now, the rule of law crisis, or at least in Europe, so it's a very good example of democratic decay and of Euroscepticism, which, when they go hand in hand, are very dangerous. So I've taken the liberty of adding an article of the Treaty on the European Union, where you can see a very stark reference to the rule of law, which is a very big principle of the state in Europe. Now, the thing is that Hungary and Poland, because of the democratic decay happening in their countries, have been more and more resistant to abiding by all the rules that are coming from this rule of law idea, such as independence of the justice, such as right to a fair trial, and so on and so on. So here you have a little statement from a joint declaration of Hungarian and Polish Prime Minister in November 2021 that neither Poland nor Hungary will accept any proposal that is deemed unacceptable by the other. This was at the height of this rule of law crisis, making it very hard to have this idea of democracy being respected, or at least it was very, very scary for Europe and the scene in general. So, yeah. So, as for the European Court of Justice, so very shortly, it was created in 1952. It is a body of the European Union. It rules on the application of EU law in national countries. This is very important because it really shortens the scope of what they can do. It's only when EU law is in cause and only within what has been decided before. And it has jurisdiction over member state of the EU. Whereas the European Court of Human Rights is a body of the Council of Europe, which is not a EU institution, and hence does not have jurisdiction only on the member state of the European Union, but also on states that are part of the Council of Europe, such as Turkey or Russia. Made a mistake there, or Russia before March 2022, because they have left the Council of Europe during the crisis with Ukraine. And it rules on the application of the European Charter of Human Rights by member states. So, is democracy protected by the European courts? Once again, if you have an answer, do not hesitate. Otherwise, just think about this question for the next few slides. So, in the first part, we will see about the protection of democracy through the upholdment of a democratic standard. First of all, we'll see about the importance of the appearance of democracy with a very important case, I think, from the European Court of Human Rights, which is Schramek v. Austria of 1984, and then we will see about the importance of the independence of judges in Poland and in Hungary, and touch up a bit about a new solution that has been found. So, on this case, there was a land acquisition dispute between the applicant and an authority statuting on whether she could or could not buy that land. This authority was seen, as the applicant said, as a body that was not an independent and impartial tribunal constituted by law. So this is against Article 6, paragraph 1 of the European Charter of Human Rights, which is a right to a fair trial pronounced by an independent and impartial tribunal established by law. So the court found that it was very important that there was no doubt about people's independence when they were part of a judicial body. Because in such a situation, it would affect the confidence which the court might inspire in a democratic society. So this idea of not only has a body be fair, right, or righteous, it also should be as it also should also be perceived as it is. And this is very important because then it heightens the standard of expectations of the people when it comes to a judicial body, which leads also then to more care and more suspicion when this is not the case, which then, in my opinion at least, helps making people more suspicious of democracy going away. Then on the importance of the independence of the judges. So here we have two Polish cases that go, for me, hand in hand. So we have the case of Grenda v. Poland of March 2022 and the case of Jurek v. Poland of June 2022. So both of them are a very stark example of what was happening during the rule of law crisis, and they were really important because this rule of law crisis was caused by the judicial body being not independent, or his independency being taken away from them. So it was the judges, but also, as you can see, the National Council of the Judiciary, which was the body that was in charge of making sure that all would be good, for they were the disciplinary body for the judges in Poland. So the first cases was an instance where a judge was removed before the end of his term by this National Council of the Judiciary. And he was not able to get judicial review of that decision because there were no pathway being there before, and also there were no way for him to get judicial review, so a second opinion on that decision. This was against the right to a fair trial and also the right to access a court. Here, the issue is not as much as that there were no way, but what the court found is that there was a very strong interference by the executive and legislature on the judiciary, and that the independence of the judiciary was substantially weakened. The second case is kind of the following, or episode 2 of the first case, because once again there was this idea of not access to a fair trial and also weakening of judicial independence, but also that in this case it was a judge who was a spokesperson of the previous body who removed the judge, that was removed on his turn and could not stand his removal because he was very open about his dissenting opinions about the reforms that were taking place in Poland during the moment that my colleagues before have talked about. It also challenges the Article 10 freedom of expression, and basically the court was quite severe in this. And it's also very interesting because they coined this term of rule of law crisis. And now the thing is that this rule of law crisis was so stark that the European Court of Human Rights could not do much, and the European Court of Justice, even though they tried, could not do much either, because their possibility to act was very much restrained not by the idea of human rights, but by the idea of it should be EU law. The thing is that there is not that much defense of EU law on a EU level. So they had to find something else. And because the judges could not get too inventive in their decision and create the highest standards where we could have seen this happening in the European Court of Human Rights before, they had to find something against, this situation, where you had Hungary and Poland being really hand in hand and quite friendly against this very mean Europe, and they were really cultivating this Eurosceptic behavior that they had, to the point where, at some point, Zbigniew Ziobro, which is who is or was, I think, but I have a doubt because I wrote his name, but I forgot who wrote his position. But I think he was the president or something. But he was a high official who announced that a judgment advanced by the European Court of Justice would be referred to the Polish Constitutional Tribunal, which is a very politicized body, which was very problematic because not only had the European Court of Justice a very narrow way of acting, now it would also lose legitimacy, and there would just be no compliance to EU legislation. So it was also against the rule of law, hence the name rule of law crisis, because as said before, the Constitutional Tribunal was very politicized. Then got in a lot of things happening all at once. there was a proposal of a conditionality regulation named the General Regime of Conditionality for the Protection of the EU Budget. The thing is that they found a way, so the Council of Ministers and the Commission found a way together to create something based on, once again, economics, because it was very important that it would not be human rights. Based on economics and the idea that EU budget must be balanced and that there would be no reason to give money to countries that were challenging and putting this balance into danger. And here, so it was opening the possibility for financial sanction if breaches of engagement to the respect of different principles, such as the rule of law. And it would then be a way of enforcing the rule of law much more easily. So in this idea, if dialogue was not enough in case of breach, then implementing a decision would be then possible. But it would also be possible only by only a qualified majority and not an absolute, because as you can see, if it was an absolute majority against one member, since they were friends, there was talks about this blood pact between Hungary and Poland. Since they had decided that at no point whenever would one of the two talk bad about the other one, it would make an absolute majority completely useless. So there was this downgrading to a qualified majority. And the scope of this rule of law regulation was only limited to breaches threatening the budget or financial interest of the EU sufficiently. And this sufficiently is also a bit of a problem in this rule of law regulation, but it still is a new tool for the European Court of Justice to be able to prevent attacks against democracy. And yes. Now, on the second part, we will see about the protection of democracy through the defense of human rights. First, on the use of specific human rights for the protection of the access to participation in the democratic process. So basically, we will see about the prisoner's right to vote. And then we will see about the use of specific human rights for protection of the watchdogs of democracy. So those two rights are the freedom of association and the right to privacy. So first of all, when it comes to prisoners' right to vote, a very good principle to have in mind when it comes to the European Charter of Human Rights is that there is usually not a possibility of a general exclusion of anyone. Blanket ban are not a thing. On the national level, they can be, which is a problem. So in this case of Hurst, which is the second case, Hurst versus the United Kingdom of 2005, there was a prisoner serving a life sentence that was banned from voting because at the time the UK was implementing a blanket ban, so every single person convicted and in prison were not allowed to vote, which was against the third article of Protocol 1, the European Convention of Human Rights. And the court found that there cannot be automatic and indiscriminate restriction of the right to vote based on the status of convicted prisoner. A few years later, and I think I took this example because it really highlights how there is a continuity usually when it comes to jurisprudence, which is very interesting in the defense of democracy, because a good decision leads to better decision, whereas a bad decision can lead to worse decision. Once again, there was a prisoner serving a life sentence, once again for manslaughter. And he was also subject to a ban on voting, touching all the prisoners convicted of a sentence longer than 1 year. So not all prisoners, but almost all of them. Once again, the same mechanism was used, but the court was also referring to its previous jurisprudence of the Hearst 2 case. And then they gave out a very detailed list of criterions that should be checked in order to ban someone from voting from inside the prisons. So the decision should be taken by a judge, taking into account the specific circumstances of the case, and there should be a link between the offense and the ban. The idea is that being prevented to vote should only be an exception. This is, I think, very important when it comes to democracy, because it would be too easy to, in the idea of a very bad slip in the wrong direction, to put everyone that does not agree with the regime in a place where they cannot vote, so prison, or just convict them of some kind of offense and then ban them from voting, and then assuring yourself a steady base of all those who agree with you, and then always taking out of the voting pool those who don't agree with you. Now, when it comes to the use of specific human rights to protect the watchdogs of democracy. So the watchdog of democracy usually are the press and association in general and political parties, but here we will talk a little more about, about political parties, and the next one would be with the press. So, freedom of association. In this case, there was this HIP party. It's a very long Turkish name, and I can't speak Turkish, so HIP will it be. Was dissolved in 1993, 3 years after being founded. It was dissolved by the Turkish Constitutional Court on the grounds that its activities were likely to undermine the territorial integrity of the state and unity of the nation. This HIP party was supporting the idea of a Kurdish minority, defending the idea of Kurdish people being able to speak their languages and having rights. The solution of this HIP party was against the Article 11 of the CHR, so right to freedom of assembly and association. Here is an extract of the second paragraph of this article, that no restriction shall be placed on the exercise of these rights other than such as are prescribed by law and are necessary in a democratic society in the interest of national security or public safety. This exception is usually found under quasi all the article of the ECHR, and that's also what makes them applicable and acceptable by the states. So the results of this case was that the court found that, first of all, right of self-determination and recognition of language rights are not contrary to the fundamental principle of democracy, but also that the proper functioning of democracy requires political grouping to be able to put forward to the discussion tables uncomfortable topics, because they contribute to public debates in order to help find solutions to problems of general interest. This is very important because it gives a protection for every small parties, every small dissenting parties, and it's very important because if you do not have an alternative party to the one in power, then you have no possibility of change. So the idea is that by providing more options and discussions, democracy will arise because people will be able to make an actual choice and not a default choice. And it also prevents autocratic governments to make sure that they are the only one on the list. Then we will talk about the right to private life. Not sure if you've noticed, but the previous one was from Turkey. This one is from Russia. Those are the cases of the European Courts of Human Rights. It's important to note because all the cases that I will be presenting to you today, and I think this one is the last one. Yeah, this one is the last one. All the cases that I've presented to you today are only cases of the European Court of Human Rights because it's de facto, because of its nature and its role, the most efficient body when it comes to defending democracy. The thing is that whilst it has the possibility of making a judgment, it does not have much option when it comes to actual sanction. It's more the reputation of a state and the public perception of the state on the international scene that would be affected, and this is very powerful, but it's still very light compared to this idea when it was when I was talking about the rule of law regulation of preventing receiving money, withdrawing money, retaining some payment, and actually putting a state in a state of discomfort. Here, besides international shame, there isn't a lot more options of actual punishment of the state, but it's also not the point of the European Court of Human Rights. The idea is that every single state take part in this European Court of Human Rights adventure with the idea that the goal is to be better and to have a better standard of democracy, of human rights, and to, through each time having a bit of discomfort when they are found to not be up to the standard that they thought they were, have ways and paths that they know they can take in order to be better. Yes, so onto this case. In this case, the case of Roman Zakharov against Russia of December 2015, we had the issue that in Russia there is this law, or at least there was, this law under which all mobile networks operators were required to install a surveillance system on every single line and mobile that they were providing. This was making mass surveillance of the people very easy because the tool was already there. An editor-in-chief in Russia complained about that because it is a thing to be complained about. And the European Court of Human Rights found that indeed this was very much a problem. So they used the Article 8, which is the article that gives you right to private life and family life. And the first paragraph of this article states that everyone has the right to respect of his private life, family life, his home, and his correspondence. In this case, it was not as much as the private and family life, the home, but really very much the correspondence. Correspondence is about mobile phone, telephone calls, emails, but also letters, because it's what it was intended for at the beginning. But here, correspondence really covers all of it. So the result in this was that the court found that this law was very problematic, not because it was giving a possibility, but because those possibilities were completely deprived of adequate and effective guarantees against arbitrariness and the risk of abuse. Once again, this is something that is very important to have in mind, is that those rights are not absolute, and there is always possibility to subtly change things. When I was comparing the two cases with the prisoner's right to vote, you would be able to see that in the second case, Austria had tried to narrow it and to subtly also still have a ban. And this way of making new ways of having control, and this is provided by the second part of usually the articles. So I think that's, yeah. So the second part, those no restrictions shall be placed that are taking place in the second paragraph of usually pretty much all the articles, are what are giving the possibility also for the state to still have sovereignty and to still be functional. Because whilst the European Court of Human Rights does not allow for complete ban, the European Court of Human Rights also does not completely ban. It is a two-way street, and it makes things much more functional. So yes. Now, to conclude, it's important to keep in mind that the roles of the judges in defending democracy is very important in national level, but also in the European level. Maybe not as much as we could like, but this is a question for debate, because then it touches on the idea of sovereignty and who has the right to submit a state to a decision. But very limited when it comes to the EU judges, because that is not their primary role. Having judges defending democracy is very interesting because it challenges the authority of states and their sovereignty, and this is happening only because they have accepted it. The decision of Russia to withdraw from the Council of Europe is a very big example of this, that what is given can be also taken back. If Russia decides to get into the European Council, it can also decide to get away from it. This idea of states being submitted to a judge is only possible because the states allow for it and submit themselves to it. So when you have crises like Hungary or Poland that are being the bad children of the EU and that are making decisions and not complying to decisions and being against this idea of rule of law, not necessarily listening to what the European Court of Human Rights might have said, and this is also not something that just Poland and Hungary do. When you look at France, it's systematic that every single year you would have France being struck because the living conditions of prisoners are not up to standard. So when you have those states not being good enough and thus being struck by judgment, it also means that they accept of being struck by those judgments. And this is something that should be, I think, really kept in mind. And then also a very big question is the level of protection provided by the supranational courts. So there is this idea that if the supranational courts try to take too much to the states will go away. But if they do not do enough, then they're basically useless. And then the states, once again, do not have very much reason to be in them, or at least they would go in those entities just for the good publicity, and there would be no actual benefit from the people. So yes, I hope that it was interesting for you. I think that I am right on time, so yeah, good.
We should maybe go back to the questions that you asked.
Yes, that was, so the questions were, so is democracy protected by the European courts? I think that this has been answered.
Well, what do you think?
But the first question I would very much like you to answer now. So, yeah. Do you think democracy should be sufficiently protected? And now I'm not only talking about the courts, but just your opinions. What do you think? Do you think that this protection should be also seen in another way than protection by the court?
Nobody has an opinion?
I'll have the microphone for your questions or comments. When you start, I'll come with you.
We're all happy with the protection of democracy thanks to the EU courts and the Council of Europe.
Yeah.
Not quite. Anyone see a hole in the...
Okay.
I think, especially with having heard the presentation before, I think it's also really interesting concerning that question to make a link, for example, to the internet and to the virtual space, because as you said, it's not only courts that can protect democracy or have a say in this. And I think, for example, the internet is, for example, a place where also democracy is contested and where it's really challenging with all the algorithms that we talked about. Getting you into filter bubbles that only reflect your opinion and so on. So I think that also that is, for example, a place where we should talk about how we can protect democracy in a way that the internet can be, or because it also has the potential to be a space of discussion, a space of different opinions coming together. So, for example, that would be another element that could be considered.
Yeah. So if no one has any other questions, I think I will spare your eyes.
What?
Oh, yes.
More than a question, it's like an opinion. According to what you said, I think that there is a truly strong relationship between democracy and protection of human rights. So there are countries nowadays, as we know, where the protection of human rights is in serious danger, as we know. So I think that democracy will be sufficiently protected only where in most of Europe, if we want to concentrate on Europe, but this kind of discussion should be more, complete according to the world, where every country, every reality in Europe as in the world, only once the human rights are guaranteed and protected. For example, before we're talking about Poland or other kind of realities where these kinds of discussions are in danger. So, in my opinion, we can only talk about democracy if we look at the respect in a country of human rights. So, as you said before, a central role in this kind of activity is of the Council of Europe, as we know. But in my opinion, it depends on the government. It depends on the single state, the single country, and it's very. I don't know how to explain better, but it's very complex, and we are so far from a good result, in my opinion. We're far from.
Well, I do not agree, but I respect your opinion very much, and I think that this is a very good example as for how hard it is to have a good protection of human rights, because even only just in Europe, which is not the whole wide world, but just in Europe, we have very big difference when it comes to, I don't know, the standard of treatment of prisoner, which is maybe better in a country which we don't see as the countries of human rights, and then we have the situation in front which is drastic, and then we have problems when it comes to other areas of human rights in Poland, and the situation being way better in other places, such as, I don't know, Germany. And this is only a body of regional protection. It is the most complete. It is the one that has the ability to produce the more results. But there has been also a charter of, so I don't know the name in English, but I know that there's an African Charter of Rights.
I know.
With a longer and more complicated and complex name than that. But who also has this interpretation of human rights for the African continent. And I think that this is a better way to have better results, even though the result will never be perfect because the states.
Yeah, but for example, in Italy, you know, if you think about Italy, you think it's a perfect place, no, where to talk about democracy and respect of people, and that's it. But in these days, in these last weeks, for example, we had some examples of democracy at risk, you know. For example, because it's not very common to talk about this kind of things. But for example, when you want to express your own opinion, no, you're not always allowed to do it, or other kinds of things that maybe you don't pay attention to what is happening in general, none of us. But if you reflect on what's happening nowadays in Europe in general, democracy is at risk. In my personal opinion, I know that maybe there are people who disagree with me, but I don't know. I'm afraid of coming back to the past. So.
Yeah.
Also, I think that judges, of course, have to apply laws that are made by Parliament. So that's, of course, a political, historical process, and you must combine many different factors. So, of course, it is protected, democracy as a concept, by judges, but it's not enough, because we should have a protection that's more wide. And you know, it's also about our values, about what our parliaments discuss and approve. And it's like we are having many problems on freedom of
freedom of speech.
So if a law were to pass, judges would have to apply that, and that's very bad. So of course, it's not enough.
That's why it depends on the government of a single country. I don't know how to explain better, but the situation in Italy nowadays is very strange, very weird, and we need to pay attention to what's happening every day by day, step by step.
Yep.
Yes. So I'm not very optimist.
Okay. Does anyone else know? Then in that case, I will.